While the Arizona homestead exemption provides powerful protection for homeowners, it is not absolute or permanent. The law recognizes certain circumstances under which the exemption may be terminated or forfeited. Understanding these situations is critical for both homeowners and real estate professionals, as the loss of a homestead exemption can expose a homeowner's equity to creditors or affect the handling of proceeds during a sale. The rules governing termination of the exemption are found primarily in ARS, Section 3033, 1104, and ARS, Section 3033. 1103, and they serve to balance the homeowner's right to protection with the legitimate interests of creditors and the realities of property ownership. One of the primary circumstances that leads to the termination of a homestead exemption is the sale or voluntary conveyance of the property. According to ARS, Section 331101, when a homeowner sells or otherwise transfers ownership of their primary residence, the homestead protection no longer applies to the property itself. However, the law provides a continuation of protection for up to 18 months after the sale, as long as the proceeds from that sale are intended for and used to purchase another qualifying primary residence. This means that if a homeowner sells their property, deposits the proceeds in a bank account, and uses that money within 18 months to buy a new home, the exemption still applies to those proceeds. But if the money is used for any other purpose, such as investing in stocks or paying unrelated debts, the protection is lost, and creditors can legally access the funds. Another circumstance that terminates the homestead exemption is the abandonment of the property as a primary residence. The law under ARS Section 33-1104A3 specifies that the exemption ceases if the property is no longer occupied as the owner's principal residence. Intent is a critical factor in determining whether a homestead has been abandoned. For instance, if a homeowner temporarily moves out due to medical treatment, military deployment, or a temporary job relocation, but maintains an intent to return, the exemption remains in place. However, if the homeowner moves permanently to another property, rents out the old home, and establishes a new principal residence elsewhere, the exemption is deemed terminated. Courts look closely at the owner's actions and intent, including changes in mailing address, voter registration, and where the owner physically resides, to determine whether abandonment has occurred. The homestead exemption may also terminate through death of the owner, unless the property passes to a surviving spouse or dependent family member who continues to occupy it as a primary residence. In such cases, the protection extends to those heirs under ARS Section 33-1101C. For example, if a husband who holds the homestead exemption passes away and his widow continues to live in the home, the exemption continues uninterrupted. However, if the property is sold as part of the estate or the heirs do not live in it, the exemption ends, and creditors may make claims against any equity not otherwise protected. Another circumstance leading to termination is the execution of a forced sale by creditors holding secured debts. The homestead exemption does not prevent foreclosure by a mortgage lender, a tax authority, or a mechanic's lien holder, as these are secured debts attached directly to the property. When foreclosure or a tax lien sale occurs, the exemption is automatically extinguished because the property has been transferred through legal process. For instance, if a homeowner defaults on their mortgage and the bank forecloses, the homestead exemption cannot stop the foreclosure, as the mortgage is a consensual lien that supersedes the exemption. Additionally, the exemption may be forfeited when proceeds are not reinvested within the statutory timeframe. As noted earlier, if a homeowner sells their property and fails to use the proceeds within 18 months to acquire a new primary residence, the exemption expires automatically, and any remaining proceeds become accessible to creditors. This provision ensures that the exemption serves its intended purpose, protecting a home rather than functioning as a general financial shield. A practical example can help illustrate these principles. Suppose an Arizona homeowner sells their residence for $450,000 and has $350,000 in protected equity. They deposit the proceeds into a savings account and intend to buy another home. If they use those funds within 18 months to purchase a new residence, the protection continues seamlessly. However, if they delay and use the money after that period, or if they relocate out of state, the protection lapses, and creditors can pursue the funds. Similarly, if a homeowner permanently relocates to another state and rents out their Arizona home, the exemption no longer applies because the property has ceased to be their primary residence. The courts have consistently upheld these termination principles. In In re Smith, Banker d. Arizona 2005, the court ruled that a homeowner who moved out and rented their property had effectively abandoned their homestead, thus forfeiting exemption protection. Likewise, in Evans v. Young, 1970, while the court emphasized the liberal interpretation of the exemption in favor of homeowners, it also affirmed that once the statutory criteria, such as continuous occupancy and intent, are no longer met, the exemption ceases to exist. Review summary. The Arizona homestead exemption, though robust, can be terminated under specific conditions outlined in ARS Section 33-1103 and Section 33-1104. The exemption ends when the property is sold or voluntarily transferred, unless proceeds are reinvested in another home within 18 months, when the homeowner permanently abandons the property as their primary residence, upon the death of the owner without a qualifying heir continuing to occupy the home, or through foreclosure or tax lien sale due to secured debt. The exemption also expires if proceeds from a sale are not timely reinvested in another qualifying residence. Understanding these limitations helps real estate professionals guide clients through transactions, ensuring that homeowners maintain or properly transition their exemption protection. Discussion. What is the primary factor that determines whether a homestead has been abandoned? Answer. The homeowner's intent to continue using the property as their principal residence, demonstrated through actions such as maintaining occupancy, mailing address, and utility accounts. Why does the law allow proceeds from the sale of a protected home to remain exempt for 18 months? Answer. To give homeowners time to reinvest in a new primary residence while maintaining continuous protection of their equity. Can a homeowner who moves out of state retain their Arizona homestead exemption? Answer, no. Once the homeowner establishes a new primary residence outside Arizona, the original exemption is terminated because the property is no longer their principal residence. Closing remarks. The Arizona homestead exemption provides significant protection, but that protection depends on continued occupancy, intent, and compliance with statutory requirements. Real estate professionals must be aware of the events that terminate the exemption to accurately advise clients during sales, relocations, and estate transfers. By understanding these rules, licensees can help homeowners preserve their rights and avoid unintended financial exposure. The homestead exemption stands as a pillar of homeowner protection in Arizona, but its benefits endure only as long as the homeowner continues to meet the law's conditions.